In the world of business, not all deals are what they seem. Fortunes rise, empires crumble, all with the stroke of a pen. Mergers, acquisitions, hostile takeovers. Welcome to Mergers She Wrote, where we examine strategies and stories behind the biggest deals in business. Because in M&A, the real risks are the ones you don't take. Welcome back to Mergers She Wrote, Episode 7. I'm your host, Paloma Goggins, the owner of Nocturnal Legal, a business law firm devoted to mergers and acquisitions. I'm here today with Sarah O'Keefe. She is a partner at Shields, Petit & Zolden. She has broad experience with everything from litigation and workplace investigations to OSHA compliance and disability accommodations. She advises clients on compliance, risk management, and employee training, all with a focus on fostering fair, safe, and legally sound work environments. She's recognized as a Best Lawyers Ones to Watch and Super Lawyers Rising Star. And Sarah brings not only her legal acumen, but a passion, proactive solutions in the workplace. Thanks so much, Sarah, for being on today.
Oh, thank you.
So, as you know, Mergers She Wrote is really centered around trying to help people who are building and scaling their business with the idea and plan to eventually exit. And today, Sarah and I are going to kind of discuss back and forth what are really common topics that we have with business owners about, generally speaking, their relationship with their employees, being an employer. So first on our list of questions, our Q&A, is when a business is scaling and thinking about exiting in the future, what do you think is the most common mistake you see founders make when it comes to classifying workers, employee versus independent contractor?
Yeah, that's a big one, and it can definitely be like a bet the company problem. Probably the number one is sort of like misunderstanding what the legal tests really are. And then, if you're doing that, you're misclassifying the employee kind of from the jump. And a lot of the tests are really about control and like how much control the employer can exert over the independent contractor / employee. And there's also a bunch of different tests. So like there's the IRS test, and each states have their own different tests. There's Department of Labor Economic Realities, and California has their own tests. There's a whole bunch. So it's a trap for the unwary if you're, not well versed in that. Definitely consult an attorney before you go down that road for sure.
Would you say that if somebody was just trying at a baseline to determine whether they have things right or wrong before consulting with an attorney, is there one test they should look at just for their own sanity or gut check first before having to dive deep into getting an advisor?
Control is definitely the focus, right? So for an employee, you can dictate everything, all of the terms and conditions of employment. For an independent contractor, however, you need to make it seem like that person is free to go and compete with you, work with other businesses, etc. And so you can't have too much control or the discretion to exercise too much control over that person. You do not want to set schedules. You don't want to provide materials. You want them to bring like their own tools and everything. You don't want to share branding. All of that stuff is indicia of employment. So avoid all of that. But if it's somebody who's like integral to your business, like the business can't function without them, you're probably in employee space opposed to independent contractor.
So you had kind of hit on something that I would like to get your thoughts on in addition to like just the general classification, and I think control is a great way to put it. When you're talking about not necessarily limiting someone from competing, can you, in fact, for a 1099, can you put some parameters in there? Because I think there's always some level of concern, especially those businesses that are creating deliverables or work product, where if you don't have something in there that prevents them or limits them from competing in some capacity or taking their, hard fought after clients away from them after they've worked with them internally in your business. Can you do that on a baseline level, and to what degree, and answer how you feel comfortable? Because I know, Sarah and I are both lawyers, and I feel like we both know the idea of like answering questions on a podcast that exists in perpetuity is not necessarily. Disclaimer, right. This is not legal advice.
Thank you.
This is for informational purposes only. Thank you. Continue.
Perfect. Thank you for that. Yeah. So there's a lot that you can do. And when you're doing it, just kind of be careful, right? So you definitely want agreements like confidentiality, non-disclosure, how the IP is going to be treated, that whatever work the independent contractor is doing for you when they're working for you is your product, not the independent contractors. All of that you can do. Just be careful when you're doing it, basically. And a lot of people are like, oh, can I put in a non-compete? No, please don't do that. Because you're really saying like that person's your employee by just doing that. So yeah, have confidentiality, non-disclosure, assignments of rights and IP and all of that good stuff in there. That's totally fine.
So when we talk about non-compete, and maybe this is digging a little too deep on this specific topic, but like when you say not putting in a non-compete, could you still potentially limit their ability to steal just your clients specifically? Like instead of a more general concept of non-compete, which is like going out and doing the exact same thing that you're doing out in the marketplace.
Yeah. So typically, and this varies by jurisdiction, of course, but generally courts are more lenient when you have things like non-solicitation agreements. So like you can't target our customers, clients, prospective clients, employees, vendors, suppliers. That gets a little dicey. But mostly those are all fine. And they make sense, right? Because you just want to have reasonable restrictions to keep your business competitive. And that's okay for the courts. On the non-compete side is a little bit more tricky, right? Because those, you need to have reasonable scope, define what the job is really clearly, the duration of time, and a geographic space. You don't necessarily have to have that with a non-solicit, but it could be good to help make your agreement potentially more enforceable if, God forbid, it got challenged, right?
That's fair. And for listeners, geographic region, and I'm, coming from a place of general business knowledge, geographic region, I think can be a really key piece of the enforceability. And correct me if I'm wrong, but like, I think generally speaking, the broader the scope, the potentially less enforceable, correct?
Definitely. Yeah. And I mean, if you think about it, like if you're going to do a provision where you're like, okay, nobody within 5 miles, you can't solicit any of these people, you can't compete. It's a 5 mile like radius, right? And when you're talking about like that's probably reasonable. But if you go with something like all of Phoenix, not reasonable, not going to be reasonable, because you're basically saying that person can't, work in their chosen field in that space. You have to move.
Yes, very true. And I will put this as a caveat because the podcast is geared towards people buying and selling businesses. This conversation is about employee and 1099 type restrictions. The non-compete language in like a purchase agreement for an exit is far different. Don't think that this applies the same. You can make that much more enforceable with more general broad strokes than if you had to try and do this with the 1099, as
for sure.
Sarah was saying.
Yeah, definitely. Your key man agreements are going to be very different. Like somebody who is the business, that's okay.
On a personal level, when you saw recently in the past year all of those, news updates about how potentially the non-compete generally was at risk of being just completely wiped out, did you think that was going to survive and get passed? Like, what was your personal opinion, just coming from an employment lawyer perspective?
Yeah. The FTC's potential, non-compete ban got everybody all really excited and worried about like, what's that going to look like? Because obviously that would be a huge measure, right? You would not have non-competes. The FTC was trying to say that that's their area to regulate. From kind of knowing what the background is and how these things go, I wasn't too worried that it was actually going to, pass without legal challenge. And there are still many pending legal challenges. So we'll see what happens. But a lot of people take the position that that's like not within the FTC's jurisdiction to regulate, really. And There's some sense to that, right? Like, who knows what the business is? There's a whole lot of things in their proposed rule that like didn't really account for everything. So it's probably for the best that nothing else has happened, but definitely there is this perception, and I probably share that like you shouldn't be able to restrict your competition out of business. Like it's not about competition, it's about unfair competition.
Well said. I think to your point, there was a lot of humdrum of like, okay, am I gonna all of a sudden as an employer have a lot of potential liability for me to like have my business change, right? Because all of these employees are no longer going to have the non-compete. And then also on the flip side, people who had employment agreements that were like, yes, I can go out and immediately compete with the business, free reign. As like a standard right now, in lieu of any of that being passed, every state, like you had said at the outset of what you were describing, has its own restrictions. And there's even some I've come to learn just in doing deal work that are industry specific, like medical field has some specific carve outs sometimes. And so I like to say that as a caveat to anyone listening, it really depends on jurisdiction, where you're located, potentially where your employee is located, right? Because I think, too, one of the big questions that always gets asked of me, and I'm not really entirely sure how to answer it other than go talk to an employment lawyer, is whether you being an employer here in the state of Arizona and then your employee is based in a different state, what laws apply? And is that on a case-by-case basis, or is it typically where the employee is based?
It's typically where the employee is based, right? Just be cognizant, like you definitely want to know where all your workers are for compliance purposes, right? And then you want to comply with your own like home state laws. But for the most part, if you have an employee that's in California, they are going to try to avail themselves of all of the wonderful California rights that exist, which are like a different world from here.
Oh, it's so true. For anyone listening who has employees or especially independent contractors based in California, please know that there are all sorts of specific rules and limitations that make having a 1099, especially in California, a very dangerous proposal.
Yeah. Don't do it.
Don't do it.
Better yet, get out of California.
All right. So related to classification of employees, can you walk us through the legal and financial risks that a business might have for misclassifying an employee, especially thinking about how a lot of these issues only come to light during due diligence. If a business has been growing and scaling for 30 plus years, the owners are ready to retire. They're now just gathering all the information. Perhaps they haven't worked with advisors as they should have along the way, and there's some non-compliance. What are some issues that could come up, especially from a liability standpoint, right? Because nobody's going to close and buy a business with outstanding liabilities.
Right. They're absolutely going to want to know who gets what. So there's a ton of risks, basically. Like you have your normal employment law issues, which could be like wage and hour under the Fair Labor Standards Act. So that could be things like you're not meeting the minimum wage, you're not paying overtime, you're not dealing with like meal breaks and rest periods. And then you have like laws that are going to apply that otherwise wouldn't, like potential, anti-discrimination laws. So your misclassified workers may be entitled to some additional protections under like the ADEA or the ADA. And then you could have the normal sort of run of the mill wrongful termination or like retaliation claims. And leave entitlements, that's a big one. So post-COVID, there's all these laws that we have to comply with paid sick leave and all that good stuff. Then apart from employment law risks, you're really talking about like tax violations, which is the big scary, which can be like your income tax withholding, Social Security, Medicare, FICA, all those taxes that you have to worry about. So if you've misclassified an employee, you're going to owe those back taxes plus penalties and interest and all those terrible things that could potentially put you out of business. And a lot of things, we also see some benefits issues, right? Like if there are some discrepancies in the plan, people will argue that that's potentially discriminatory. So you want to have like all of your ERISA ducks in a row. And also like the state level enforcement can be pretty vigorous depending on where you are. So you want to be worried about like the audits and all those kinds of things. Obviously, it's going to risk your deal potentially, right? Like somebody is not going to want to take on this company with potential unlimited liability. You need to know what those liabilities are, and you guys need to break them down in the deal process so that everybody is clear about who gets what.
That was exceptionally comprehensive. I appreciate that answer. And I think too, the potential for having outstanding liabilities when it comes to employee classification is something that's probably overlooked in comparison to something like outstanding taxes or liabilities on the business from like an annual filing perspective, or collateralization of assets and having taxes pull those assets back. Obviously, if you're buying an asset, sale as opposed through a stock sale or an equity, maybe you could get the buyer on board with the fact that you're like leaving behind a lot of the liability from the old company's employment practices, and like that's predominantly their problem. And everybody that comes over from an asset purchase will get a new employment document of some form with the new company buying all the assets. So in some cases, I would argue that if you did discover that you had all these potential misclassifications and extending liabilities, that and you were doing an equity-based sale like a stock or a membership interest purchase, that the only way that you potentially could save the deal at some point is to change it to an asset sale. And so I find that, this idea of an audit, okay, fast forward, someone sells an asset, all their assets to the business to a new buyer. They have essentially walked away from the liabilities related to that, old LLC that had all the misclassifications. An audit occurs. Is it like taxes where the audit can look backwards for a number of years? What would, like, if you were a business owner and you sold all your assets and like all of a sudden discovered that you were getting audited by the state, what does that look like just on a baseline level for someone?
Besides immediately like paranoia and fear, you're like, oh God. Yeah. So it absolutely can look backwards, right? And typically the timing is like 2 to 3 years, generally 2, 3, if someone can argue that like it's willful, for things like misclassification or like not following Fair Labor Standards Act, et cetera. So those are a little bit scarier, but it's all really like fact intensive, right? So if you don't have that documentation and like you didn't have a good housekeeping in order, it's going to be really quite terrifying, right? And one audit may trigger another audit, and that also may trigger litigation from your former employees, right? And so there's a lot to unpack there that's frankly just terrifying. So like before that happens, you can self-audit, you can like consult with a professional, labor and employment counsel or M&A person who can really like put your ducks in a row so that you don't have that problem. But after the fact, oh man, that's scary. You just hope that the deal has accounted for, who's going to own what potential liabilities. And then there's also some risk with like, even if you do sell it and it's just assets, some, wayward employees might argue like, oh, well, these are the issues that were ongoing before. And so new company are not necessarily off the hook. And that's super fact intensive too. But like there's a little bit more risk with that. So just avoid it entirely and like have all of that, have the T's crossed and the I's dotted before you go down that road.
That is excellent advice. And honestly, I think people underestimate how, a penny, what's the phrase, like a dollar?
Yeah.
It was dollar saved now.
Pound, yeah. Penny wise, pound foolish.
Yes. Something like that, where it's like, doing it in advance of a closing is honestly, it's a pain, and maybe it shows that you really didn't have good housekeeping to the potential buyer. And like you said, maybe the buyer does walk away, but it gives you the opportunity to clean house and make sure that you don't have liabilities that pop up later, and potentially that, new buyer gets clawed into this disagreement. And I think one thing that can be also beneficial at doing it early, and even early as in the beginning part of a transaction where you realize, holy smokes, in the process of due diligence, someone has brought to my attention, because I didn't know it before, that I have misclassification and potentially all these liabilities, is at least if you know what the liability is going into closing, you can take a portion of that, purchase price and apply it to those liabilities, because when else are you going to have that much liquid money come into your business? I would hate for someone to close, not realizing that the misclassification has occurred for all these years. That money gets swept into, investments that are not liquid, or they spend it rapidly. I've seen that too. Or they take it and they reinvest it in another business. And now all of a sudden, all of that liquid cash is gone. And how do you pay the liabilities back sufficiently?
Yeah.
So excellent points. It's kind of on this same topic, how early in the process of building and scaling your business should someone start creating standardized employment policies and procedures? And what should those look like?
Yeah. Well, I'm kind of risk adverse, paranoid, conservative. So I would say there's no time like the present, and like immediately, like before you start making your business and like creating your baby, you should have it well papered. Definitely, if you want to start it and see if things are working before you spend the money on like lawyer fees, okay, fine. But for sure, before you hit like 10 employees, because once you hit like 10 to 15, all these kinds of other laws are going to come into play, and you will want to have like a paper documenting your compliance and that you thought about it. Also, like probably when you're going to start offering like different employee benefits, like 401k or things like that, that can be another like risk point. But definitely sooner the better. And the things like employment contracts, offer letters, you want a handbook ideally, and your handbook is just going to spell out like, these are the things that we expect as a company for you to do as an employee or independent contractor potentially. And like code of conduct, you're going to have your basic EEO principles. We comply with the law, no retaliation, all those kinds of things you want in there, because it can potentially lead you to like get an affirmative defense later, or at least it's going to be fodder for a defense if, God forbid, litigation happens.
I was just going to ask that. And so I'm glad you answered it, because I feel like a lot of people think it's just P's and Q's. And in fact, if you have policies really well drafted and someone decides that they're going to sue for some like wrongful termination, for example, and you have something in your handbook that shows that you actually told them that that was not something they should be doing, or, was not allowed by code of conduct, to your point, it provides that layer of defense or level of protection in the event someone was to sue. Tell me briefly, I know we're a little off topic here, but from a layperson's perspective, what's the difference? Because I hear, from my business clients, when they have issues with employees, like wage claims versus true litigation, like when does it fall into more of that like state-based investigation where they make a wage claim, or what I call a wage claim, and I feel like lay people call it wage claims, with the state, as opposed to full-blown litigation, which, I mean, you hear about that too in wrongful termination, but like, is there some things that fall into one bucket or the other, or is there, I guess, from a business owner's perspective, what could you at least try and protect yourself from one versus the other?
Yeah. Wage claims are really scary. And mostly because if you are an employer who hasn't paid wages, then you are subjecting yourself potentially to like the employee's attorney's fees and costs, your own attorney's fees and costs, and then up to like treble damages. So just, that's a little nuts. So we do not want that. So generally for, like if you're an employee, and you have like a smaller wage claim, typically the Industrial Commission of Arizona is going to like handle that, or can handle it for you. And that person maybe doesn't need to get an employer, a plaintiff's, attorney involved in that scenario. If you're talking about like Fair Labor Standards Act violations, that's almost always litigation, because from the plaintiff's attorney perspective, like you file it because there's all these penalties and fees that start accruing pretty much immediately. So those are much bigger risk points. But if typically under like 15,000 or something, and they're changing some of this right now. So there's a pending law Don't ask me all the details, please. But generally, like 15,000 and under, you can go straight to the Industrial Commission and just file like a 1-pager complaint on there, and that the Industrial Commission will like reach out to the employer and like basically try to get you to settle it.
Okay. No, that's helpful. Yeah, even for me, and I'm sure it's helpful for the listeners, but I was wondering for my own benefit as well, like what the major difference was between the two. So thank you. Before we run out of time today, and I feel like we'll definitely have to have another episode because the topics are so in depth that I want to make sure we cover some of the stuff, on more of a detailed level so that somebody who is actively building their business with the intention of at some point exiting, whether that's for private equity or at retirement, one and the same, these topics are so critical, and I cannot tell you how important they become during the diligence process when a buyer comes in and is turning over every stone, and all of a sudden all of your skeletons in every closet are visible. So talking about, we talked a lot about classification and misclassification and the potential liabilities there. You talked briefly about handbooks and documents that you should have. Tell me, just in a short way, what is the difference? Because I feel like a lot of people proactively and very incorrectly go to the internet and pull things off to essentially hire employees, not knowing that there's a huge difference between an employment contract and an employment offer. Yeah. And I find that so many businesses that come to me later on in their evolution have everyone on employment contracts, and they're not the type of employees that should have full-blown contracts. So just for everyone listening at home, what's the big key difference between the two?
Yeah, so an offer letter, right, is generally not going to be seen as like a binding contract, but like absent your compensation terms, really. Whereas your employment agreement is going to be like your 10-page document spelling out, here are all of the rights, obligations, and duties that you have. And you generally only need that with like a C-suite person, right? You don't need that with like your regular run-of-the-mill hourly employee typically. And there's some risk in trying to like put employment contracts into everybody because it doesn't fit. But also, why would you change the at-will status? That's a huge benefit for employers in Arizona, right? Like as it stands right now, if you are a true at-will employee, which most are, then an employer or the employee can separate ties. And as long as it's for a reason that is not illegal, then you're good to do that. But once you start mixing in employment contracts, that can imply like a specific duration. Somebody can now bring a breach of contract claim. That there's an Arizona statute that entitles you to fees or attorney's fees and costs. And so it can just like blow up something that should have been so much simpler, and that the state really, says that we should be able to do as at-will employers.
Totally. And I was going to say, to piggyback off of that, just for clarity purposes, for the business owner that's listening, the difference between at-will and someone who has contractually some form of employment, the difference really, what you're saying is an at-will employee, unless it's for an unlawful reason, you can terminate them truly pretty much at any time. Whereas someone who's under an employment contract that says like, you can only terminate me for these reasons.
For cause, yeah.
And for cause, I feel like too, and with us both, working in contracts all the time, how for cause is defined can really make or break the contract.
Oh, yes.
So, just another reason why it's a poor decision to pull things off the internet, because you just don't know what you're putting in your contracts necessarily, or perhaps you're giving your employees lots of rights and you didn't intend to. So
yeah.
Well, I feel like we got a really great conversation in. We did not cover like half the questions I wanted to ask. So we'll definitely have to have you back. But perfect. I think as a final question that I always ask everyone, is there a book or a podcast or anything that, you would recommend to a listener who's trying to, just better themselves? It could be employment law related or unrelated.
Yeah. So I did some thinking about this actually, and found a couple books that I would probably suggest. There's the Founder's Pocket Guide, Term Sheets and Preferred Shares. That one seems like a good bet by Joe Whalen and Nathan McDonald. And there's also High Growth Handbook by Elad Gill. and then Built to Sell by John Warwillow. Those all seem like really great intros for anybody who's considering this. And you could probably consider that at any point when you have your business.
Thank you for those recommendations.
Thanks.
So you had talked about how employee policies can be really important to have when you're essentially starting to offer your employees benefits, 401k, things like that. I think a super common and unfortunate thing that I see out in the world with especially Main Street businesses is that they offer benefits to employees on a disparate basis. Some employees have benefits that others don't enjoy. Can you talk about whether that's okay?
Yes. So for any time, in theory, right, you can have like different benefits. But there needs to be a tie to like a proper legal reason, like exempt or non-exempt or full-time or part-time. Otherwise, you're opening yourself up to some potential legal liability, and somebody's saying, oh, well, I'm this full-time employee, but you give this other employee who's similarly situated to me all these other benefits and opportunities. That's not fair. What's wrong with me? And from like an ERISA perspective, you really only want to do that with like the top hat agreements with your super key players. And you don't want to do that with anybody else because, again, it just, your plan can be unwound. You can get all of these crazy penalties, and it is not worth it. So in an ideal world, right, like have your plan documents, have all of that spelled out. Maybe it's in your employment handbook, or maybe it's in like special memos later on, who and why these people are getting disparate benefits, so that it's clear. Like, transparency can eliminate those potential disputes, right? If people understand why and it makes sense and it's legally proper, you can get away with it. But if there's a lot of, kind of cloak and dagger stuff, and you're not being real clear about who's getting what, that can just invite problems.
So from a best practices perspective, if you have a bunch of people who aren't C-suite executives and they're just at-will employees and there's really nothing to classify them in a different way, those should all have the same benefits.
Oh, for sure.
Okay.
Yes.
And I think the one thing that I see really common out there that, is a red flag immediately when talking with businesses who have been, operational for a very long time and have these disparate benefits is you'll see like the daughter who's also an at-will employee that, has no other special classification other than they're the daughter, that they're getting reimbursed for all of their healthcare costs, and all sorts of like crazy, or one person's getting an all expense trip paid once a year as like their, bonus instead of like a cash bonus, and everybody else is getting cash bonuses.
Yeah. Don't do that. Please.
Don't do that. Sarah says don't do that.
Please don't.
I think relatedly on this topic, you see a lot of people who have family members, especially kids that they have on payroll because one, they're trying to shelter, income from a tax perspective, but also in a roundabout way kind of benefit their kids through the business. What are some best practices for those people to make sure that they're doing it compliantly?
Yeah. Hiring family is like it's a whole nother podcast. But I would say like this is one point where like documentation really matters, even though you would think it wouldn't. But like from people are absolutely going to look, on the outside and sort of scrutinize, well, that's the owner's daughter and look at all of the benefits that she's getting. So you really want to have like a good paper trail for that person. So you want, here's the job description, here's the KPIs. You want like all of that stuff in writing. And you want to treat the family member like they are an employee. Otherwise, you can open your business up to piercing the corporate veil, all kinds of problems that could literally just destroy everything, which you do not want. So paper that file, treat the daughter like you would anybody else. Make sure that she is also like adhering to the policies and procedures of the organization. Like nobody should get a free pass. You should treat all your employees equally.
And I feel like this goes without saying, but if you're hiring, let's say you're hiring one of your younger kids who, wouldn't be a like traditional employee, maybe they're more of like an intern style role. Those kids should still be truly providing some sort of level of work in order to get that pay. They don't just get on payroll and get to play outside in the byproduct.
Right. Otherwise, they're not employees, right?
That's fair. I just wanted to have Sarah say that out loud for any business owners who are listening and don't have their kids actually providing some level of work in the business and getting this benefit.
Yeah, super risky.
So I think, we talked about the disparity of benefits. We talked about, hiring the kids and not necessarily having them work and how they should, and treating all employees the same. Have you seen, any sort of in the wild versions that you could share on a general level that you're like, hey, for, the smaller business, maybe closely held, family owned and operated, what are some things you could do right now to avoid some of these like common pitfalls?
Yeah. Definitely get your documentation in a row, like all of that good housekeeping stuff. So job descriptions, you want to do like performance reviews, you want to document whether there are, grievances, all those kinds of issues, as well as like your investigation of them. Having those documents, while sometimes like if nothing happens, it's just a piece of paper, but it could potentially be your entire defense if litigation occurs later. So really, you should definitely follow those formalities, right? Like it seems odd that we're going to do something like that with our family members, but it really is so important. Otherwise, you're risking your business. So consult legal, consult your business consultant, make sure that you have all of those documents, and preferably like you've got the employee file where you've got all of your standard acknowledgments where the family members acknowledged all of your policies and procedures and agreed that he or she is going to abide by them. And you have like your confidential medical file where any of that stuff that you're doing is kept and under a lock and key and other people don't have access to it. And then a third disciplinary file, like if necessary, where you're going to put your performance, performance improvement plans, all those kinds of things in there.
I thought of one other question tied back to the thing we just talked about. When it comes to a business that's growing rapidly and going to start hiring employees for the first time. So I feel like that can be a really common tech startup or software company issue where you start with two people who are the founders and neither one of them are on an employment position. They're just taking distributions out of the company, or a solo founder and they're just taking distributions. Once you start hiring employees, let's say you had some sort of system, maybe you went on a W-2 with your own company, you filed an S-Corp election as an LLC, you're now taking pay, your 401k setup changes. If you're matching, right, because it was just you before, if you're matching your own contributions to the 401k, and you're matching them like 100%, or whatever that requirement is, and like then you bring someone on, you have to be able to give them the same situation that you have, because unless, I guess, tell me, is there a way for you to set that up where if you're going to have the company match to some degree, whatever the lawful requirement is for matching, if you bring in that employee and you're going to have them on the same 401k plan, you would arguably have to have them match the same, right? There's no, unless you had them listed, the owner, as like a C-suite executive, and that makes them different than the at-will employee, right? I was just trying to put together the pieces of what we talked about earlier about what best practices would be there.
Yeah, and it's super complicated. Like you definitely you probably want to go to an ERISA specific person to vet that, and not just rely on like whatever your broker says either, because that's not always the best.
Well said.
Yeah.
Thanks for being on. I enjoyed our conversation. You'll definitely have to be back.
Awesome.
Thank you for listening. Please like, comment, or subscribe. This is Merger She Wrote. We'll talk to you again soon. In the world of business, not all deals are what they seem. Fortunes rise, empires crumble, all with the stroke of a pen. Mergers, acquisitions, hostile takeovers. Welcome to Mergers She Wrote, where we examine strategies and stories behind the biggest deals in business. Because in M&A, the real risks are the ones you